The civil procedure essay from February of 2002 is another straightforward, comparatively simple civil procedure essay question. It has one issue in it that a lot of people are afraid of, Erie, but other than that, this is actually an easy question. And as we get into the Erie analysis, I think you'll see that this is just about as formulaic as every other issue in civil procedure. This material makes intuitive sense. None of it is crazy, and you can always make some hay out of the facts, even if you're not exactly sure what the law is. Remember, the examiners typically are not looking for quote-unquote correct answers. They're looking for clear analysis and legal reasoning. And although I think this is a question that does call for a correct answer, I remember distinctly that answers that came down on both sides on many of the questions presented here received passing scores. So with all that said, let's go to the call of the question. We've got a three-part call. Did the court rule correctly on 1. Danco's motion to strike the request for a jury trial? Discuss. Well, this is not a topic that is very commonly tested on Civ Pro essays, and it is rarely discussed in constitutional law. But the right to a jury trial does strike most of us as being a fairly basic right. And as it turns out, this is where our Erie analysis comes in. Next, in question 2, we're asked if the court ruled correctly on Pam's motion to have the case remanded to state court. That implies jurisdictional questions, and we know that the basic elements of state court jurisdiction, at least over an extraterritorial defendant, involve a long-arm statute and then minimum contacts, purposeful availment, foreseeability, and fairness. If she is trying to get the case remanded to state court, that means it started out in federal court. So it was either some sort of federal question, perhaps, or more likely, a diversity case. Then the third call of the question, did the court rule correctly on Pam's and Danco's motion for judgment as a matter of law? Well, we'll have a separate subsection for each of these two motions, and we'll analyze the facts. We will reach some rational conclusions. So our first impression of this call of the question is that this is an obscure, strange question. This doesn't look a lot like the other questions that we've reviewed. But as we get into it, we'll see that the reason this is somewhat unfamiliar ground is because it is so simple. So go to the first paragraph. Here we get a paragraph that has a lot in common with many civil procedure fact patterns. We find out about Pam, a resident of State X, bringing suit in State X court against Danco, the underlying dispute is a contract case involving the UCC goods. Here the plaintiff thinks that she is paid for goods that she has not received. And we see, interestingly, at the end of the first paragraph, that Pam requests a jury trial in her State X lawsuit. But the statute in State X provides that no juries will be allowed to hear contracts cases worth less than $200,000. So, under State X law, Pam is not entitled to a jury trial. Move on. In paragraph 2, the defendant removes the case to federal court in State X. And in federal court, Danco moved to strike the request for a jury trial, and the federal court denied the motion. Well, we know that Danco's justification for removal would have to be based on diversity. And we thus are dealing with what law governs a diversity case heard in federal court. As a result, we need to do an Erie analysis, and we will forego further consideration of that issue until we get to it in a review of the answer. In paragraph 3, we find that this is really not a very well-written question. Here we've got an artificial situation that develops. A few days before trial, Pam learned for the first time that Danco was incorporated in State X. Now, to this I have to say, rhetorically, give me a break. As somebody with extensive experience in litigation, the idea that we would find out that a defendant was incorporated in our own state right before trial is just ridiculous. This is obviously a question written by somebody who has never actually practiced law. But, all right, we're dealing with the bar exam, not the real world, so we take this fact as a given, and we set our incredulity to one side and consider it. All right, here we've got a plaintiff who was just discovered right before trial in federal court, relying on diversity jurisdiction, that the defendant has the same citizenship the plaintiff does. Well, right then, the federal court no longer has jurisdiction, unless the plaintiff has, for some reason, worked a fraud on the court, I suppose. We might be able to figure out a way for this case to stay in federal court. But it seems to me that as soon as the court is informed that diversity is lacking, the case has to be kicked down to state court. So here in paragraph 3, the plaintiff discovers the defendant has the same citizenship as she. She moves to have the case remanded to state court, and the federal court denies the motion. Well, that looks like clear error, and we will try to figure out a way to argue both sides in the answer, but basically, this looks like the court got it wrong, and it doesn't look like a complicated issue. Next, we move to paragraph 4. Here we get into the actual testimony from trial. The plaintiff testifies that she paid for goods and that she never got them. The defendant agrees that the plaintiff paid, but the defendant maintains the goods were delivered, and then presents a bunch of evidence that appears to strongly support that claim. So, in the following paragraph, the evidence is over. Pam moves for a judgment as a matter of law. Well, that's a timely motion, but it certainly doesn't look like a motion that should be granted, because in order to be entitled to judgment as a matter of law, no reasonable jury can agree with the defendant's case, or the other party's case. And here, based on what we have just seen, there appears to be an honest dispute about what actually happened. So certainly, Pam does not look as if she is entitled to judgment as a matter of law. The court denies that motion, and the defendant, of course, opposed it, and it seems as if the court clearly got that question correct. And again, it just does not look like a very complicated issue. We're going to have to strain for a little bit to figure out how we're going to string that out for more than 2 or 3 sentences. And then the jury returns a verdict in favor of the plaintiff. All right, so the plaintiff had a strong case, strong enough to convince a jury. But certainly, based on what we read about the testimony previously in the earlier paragraph, she's not entitled to judgment as a matter of law. Then, in the last paragraph, Danko makes a motion for a judgment as a matter of law, and this is an even more ridiculous motion than the plaintiff's motion, because here the jury's already entered a verdict. It's too late to make a motion for a judgment as a matter of law, and the court denies this motion correctly. So, once again, we're left scratching our heads, thinking about exactly how it is that we're going to be able to write something very extensive about questions that are so simple and easy. Look again at the call of the question. First, we deal with the motion to strike the request for a jury trial, the only really interesting question in the whole fact pattern. Then the motion to remand, obviously it should have been granted, and then the motions for a judgment as a matter of law. Both of these obviously correctly denied. So, now what? Now, take a look at the outline of issues that I've presented, and I'll show you how we can actually make some sense out of these facts and present a substantial answer, but we are not going to be terribly pressed for time here. Take a look at the first section of the outline, Danko's motion to strike Pam's request for a jury trial. I say it was correctly denied. But first, we have to discuss the State X law. The State X law says no jury trials for contracts cases this small. But we are in federal court, and the U.S. Constitution has a guarantee for jury trials for federal lawsuits for damages. Now we have to get into the Erie analysis. And if you're not really familiar with it, study this part of the answer. This is really pretty formulaic stuff. It is not entirely unsubtle, and obviously you have to pay attention to what's going on, but have a look. First, we have to establish that the court is acting under diversity jurisdiction, which it is. Then we get into the analysis based on Erie. What does that case require? It requires federal procedural law in federal court and state substantive law. Well, to be honest with you, you can jiggle the facts around relating it to this rule and then come up with a decision either way. Now, I think the correct answer is the federal courts have considered this question, and you get a jury trial if you're in federal court. Next, we move on to the really simple parts of this answer. First, the motion to remand that Pam has brought, and I argue it should have been granted. And we have a case in federal court based on diversity. Danco's state of incorporation destroys diversity. Therefore, the court has to remand the case. Now, as we look at my answer, you'll see I try to make it slightly more subtle than that, but this is not a complicated, tricky question. And so, I say, answer it. Finally, we move to the motions for judgment as a matter of law, and here we are applying at least some reasonably sophisticated organizational approaches, but this is hardly brain surgery. So, we've got a separate section for each motion. We consider the details, and then we conclude that the court was correct in denying both motions. All right. Now, let's have a look at the model answer that I present here. And again, let me acknowledge up front that certainly with regard to the Erie issue, it's apparent that the examiners didn't care what conclusion you reached. What they cared about was your ability to do the analysis. And let me offer one final thought about what this question meant to people that took it before we review this answer. To be honest with you, plenty of bar candidates choked on this question. They simply weren't ready to handle a question this straightforward, and they lost their minds. They didn't organize carefully. They didn't make this answer as thorough as it really needed to be truly competent, and as a result, they underperformed. So let's briefly look at my answer. You'll see that the internal headings match those from the outline. I'm able to transpose them directly. Notice how in the very first paragraph, in just a couple of short sentences, I lead with the facts to set the stage for the analysis. Next, we move into the Erie analysis. I start off with the state X law, and you'll see here I'm basically just reciting the facts and explaining how the state X law impacts Pam's lawsuit at the state level. Then I focus on the U.S. Constitution, here indicating that we are dealing with an Erie issue. I analyze it succinctly, and I conclude that the basic federal constitutional right is a procedural right, and therefore the defendant's motion to strike the request for a jury trial in federal court is going to be properly denied. Okay, that's the complicated part of this fact pattern, and it didn't take that long to create a thoughtful, careful, correct answer. So now we move to Pam's motion to remand the case to state court. Okay, this is a simple issue, and we will answer it simply, but let's not forget to put in a little bit of intelligence and genuinely answer it. So notice, again, I lead with the facts and I explain what happened. Then I focus on the law. The court's jurisdiction is based on diversity, and Danco's state of incorporation destroys diversity. Therefore, we conclude that the court lacks subject matter jurisdiction over this lawsuit because it does not have diversity of citizenship. Case closed. Finally, we move to the third part, and here again, it is simple material being tested in a simple way. So we will answer it simply, but we will not forget where we are and what our job is. This is the bar exam. We need to carefully explain what's going on here. Treat our reader like a nice but helpless old person and take their hand and walk them across the street. So notice up front, once again, I lead with the facts. I explain that both parties have filed motions for judgments as a matter of law, and I explain what the law is, very succinctly and up front. Then I focus on Pam's motion. And here we have to do a little bit of legal reasoning. She has made it at the proper time. Then we recite what the evidence was, and it seems that Pam's case is not overwhelming. It should go to a jury, and that's what I conclude. Then we move to Danco's motion, and this is an even simpler issue because Danco's motion is not timely. So we were able to conclude a little bit more quickly that the court was correct in denying Danco's motion for judgment as a matter of law. And that wraps up a consideration of a reasonably recent and a surprisingly difficult civil procedure question. I say it's surprisingly difficult because, to be honest with you, I'm surprised so many people found it difficult.